have studied property, maybe Transfer of Property, Sales of Goods Act, and so on. So if you have to differentiate between these two categories of property, how will you differentiate?
Anything movable or immovable which can be transferred is a property.
Okay.
And IP is specifically like having a right over the property, like that is something unique about the property that we take, like geographical indication ki this thing can be as I know.
Okay, makes sense. So you're differentiating between the two based on whether it can be moved, whether it is a movable property or immovable property. All right, okay. And anything else?
On the basis of physical existence, we can differentiate.
On the basis of physical existence. So, as per you, Paras, conventional property can be seen, can be touched, can be perceived. Whereas if we talk about intellectual property, then it is something that exists in the abstract world. You cannot see it.
Yeah, we cannot touch basically what we basically all the other properties we can touch or something like that. But in case of IP, we cannot touch it. That existence
Okay.
is.
So what about books? Books. What about books? Books come under IP?
Ma'am, books come. I think, ma'am, the words that are written by the author are under intellectual property rights, but the
True.
book is not this. It comes under property, but not under intellectual property.
Okay.
But the words
Great.
written by the author can be considered as.
That's a very good answer. So when we talk about IP, we're talking about rights rather than some physical property or something that can be touched or seen. Of course, जो भी आपने create किया है, it will be manifested through some way. It will be expressed through some way. So words written are compiled and composed in the form of a book. So book is a physical property. But when we talk about IP, we are talking about the content and not the book itself. Okay, so that's a great answer, Paras. Thank you. So IP is more about rights. कि किसके क्या rights हैं किस चीज के ऊपर. So you create something and it can be anything. It can be any artistic work, it can be any innovation, it can be a logo, it can be a design, it can be as simple as this डब्बा that you see. ठीक है? सिर्फ इस bottle में भी there can be n number of IPs. Okay, we'll try to figure out कि क्या क्या IP हो सकता है इसमें. So anything that you see around yourself, आप जिस कमरे में भी बैठे हुए हैं, आप लैपटॉप यूज कर रहे हैं, आप फोन यूज करते हैं, आप फैन देख रहे हैं, आप switches देख रहे हैं, anything and everything around you can have some sort of IP. It may be patent, it may be trademark, it may be copyright, it may be design, and so on. Okay, so it is about rights that a creator or an innovator will have over a particular expression or over a particular property. Okay. Now, the next question is कि ठीक है, we understood कि कुछ भी हो सकता है IP में, but is there a legislation at the domestic level and at the global level, international level पे laws क्या हैं जो IP को govern करते हैं, and why do we need laws to ensure or to protect IP? Yes. Why do you need laws to protect IP, and what are the laws that exist for the protection of IP? And why is it relevant to protect IP? Let's say मैंने कोई डिजाइन बनाई है, तो उसको क्यों जरूरी है प्रोटेक्ट करना? मैंने कोई किताब लिखी है, तो उसको मुझे क्या जरूरत है प्रोटेक्शन की? Why is it relevant?
And what I believe that if this is also considered as a property. In general sense, if we have some possession of property, so we want a full and means we want the ultimate use of that property. So if we are using this property as an intellectual property, so we want that we are the only person who derives benefit from that. So if somebody not protects our rights, so it will basically will not be able to enjoy that property in that form, which we want from that.
Okay, makes sense. Yes. Chirag, do you want to say anything? Chirag, Pratap, Adila, and anyone else? No. Just think from a business perspective as well. What Paras said is absolutely correct because it is a matter of right. You created something, you wish to enjoy that. Just like any other property. If I own a house, I would want to enjoy that. I would not want anyone else to enter my property without my consent. And same goes with IP as well. So if I have created something, I should be able to license it, commercialize it, enjoy it the way I like to enjoy it. Okay, so it has a lot of commercial value, let's put it that way. If you look at the conventional form of business that existed, industrialization hua and so on, तो पहले business का form क्या था कि you should have a lot of wealth in terms of land, machinery. ठीक है कि land जिसके पास ज्यादा है या machinery जिसके पास ज्यादा है उसका business बहुत अच्छा है. Then the understanding shifted to innovation, creativity. That if you have strong intellectual property rights, look at Google, look at Mac, right? Apple, look at Microsoft. Ye sare, if you look at these companies that are making a lot of money today, they all have very strong IP, and that what makes them different from other form of businesses. So this is how your understanding of property shifted, and this is how the value of property also shifted from land and machinery to intellectual property. Okay? It can be innovation, patent, anything. For example, look at Coca-Cola. ठीक है अब कोको कोला के पास क्या है ऑफ कोर्स दे सेल बेवरेजेस एंड ऑल बट देयर ब्रांड वैल्यू जो खुद का एक कोको कोला का एक जो ब्रांड वैल्यू है दैट इज so significant that in case they wish to enter into or give license to any other person to sell Coca-Cola, they can make a lot of money through only licensing, through only advertising, right? वो सामान बेच रहे हैं कोको कोला बेच रहे हैं that is another source of revenue for them. But their brand itself to enter into franchisee agreement, etc., that can give them that can generate them a lot of revenue. Okay, so same goes for any kind of business that has a very good brand value in the market. It can be apparel, clothing भी हो सकता है वो, beverage industry भी हो सकता है, food industry भी हो सकता है, even entertainment, Netflix, Prime, इन सब के पास एक बहुत strong brand value है. Okay, right? So apart from what you're selling to your customer, that can of course have some kind of technology, etc. आप खुद एक brand भी बना सकते हैं जिसको आप commercialize कर सकते हैं through licensing, through assignment. Like let's look at McDonald's. How does McDonald make money? Just think, ठीक है? या आप अपना कोई brand बना रहे हैं, अपना कोई business शुरू कर रहे हैं. So what are the different ways in which you can make money?
Franchising.
Franchising, okay. That is one of the strongest ways to make money, and that's what McDonald's and other chains, restaurants do, that they enter into franchisee agreement, and that's how they also generate revenue. Okay, so that's the reason why is it important to protect your IP, because it has a lot of commercial value in today's world. And that is why you would want to enforce your rights. आप जहाँ भी देखोगे कि कोई और आपके creativity को या innovation को इस्तेमाल कर रहा है without your consent, you would want to question it. Okay. Other examples could be seen in the entertainment industry, गानों में. Right? आप बहुत सारे pirated websites से music download करते होगे या movies download करते होगे. Okay. That is also piracy that impacts the revenue that could have been generated by that particular entertainment company and so on. जो उसके लिए revenue loss हुआ. And if you look at the data and facts and कुछ reports देखोगे आप Google करके कि every year कितना amount lose होता है due to piracy, you will see a lot of reports, and it is a hefty amount that organizations or that companies lose every year due to piracy. Okay, and that's the reason why it becomes relevant to protect your IP, because it has a lot of commercial values. Rest you should Google on your own. देखना कि कितना अगर आपको economics कि उसमें देखना है कि कितना value generate होता है या कितना value lose होता है, just look at few reports online, you will get all the information. Okay, now the next question, so we have understood that it has a lot of commercial value and hence you would want to protect it. Now the next question arises, how do you protect it? ठीक है, I will not go into registration procedure and all. अभी बस मैं ये पूछ रही हूँ कि कैसे protect करोगे आप? Let's say आदिला ने किताब लिखी है, alright, she has written a book. पारस का publication company है. So Adila, let's say Adila has a good reputation in the market as an author, and Paras की भी जो publication company है वो भी अच्छा कर रही है. So they enter into a contract that Adila's book will be published by Paras's company. Okay, so now this is a contract between them, and Adila ने जो किताब लिखी थी वो English में थी. So published by Paras's publication house. Later on, Pratap also has a publication company in XYZ language, but not in English. ठीक है, कोई भी भाषा, हिंदी, बंगाली, तमिल, Kannada, and so on. So Pratap approaches Adila saying that, okay, let's now translate your book into this language and let's publish it. Okay. Now there's another contract between Adila and Pratap, and then they publish the book. Now Paras has a problem. Will Paras have a problem with this? What do you think, Paras? Should you have a problem with this? इसमें क्या IP का इशू क्या आ रहा है?
मैम व्हाट आई थिंक दैट कि मैम इशू इतना ही है कि जो कंटेंट था उस पे मेरा राइट था टू सेल लैंग्वेज. इफ मैम इन कॉन्ट्रैक्ट इट वाज रिटन दैट कि you can sell this in some language itself. Now, not in the you have right for the particular language, not in other languages. तो मैम ये कोई डिस्प्यूटेड नहीं है. लेकिन अगर मैंने पूरा कंटेंट ले रखा है इनसे कि आप मेरे पास ये राइट्स हैं, 15 साल तक ये पब्लिश करूंगा, और अगर उसमें ये वायलेशन होता है कि आप किसी और को सेल कर देते हो वही राइट, सिमिलर कंटेंट, तो मैम ये वायलेशन हो जाएगा मेरे ख्याल से.
Okay, okay. Anything else anyone would like to add? Adila, any observation, anything? Pratap, Chirag, Lizanja, anything? See, this is where a lot of disputes arise. जब contracts होते हैं, जब license agreements होते हैं, apart from infringement in the sense कि बिना consent के आप, let's say Adila की किताब पारस ने publish की है, and what I did as a local publisher, मैंने आदिला की book का पूरा photocopy करा दिया या scan कर दिया, and then I'm selling it for 10 rupees, 20 rupees or something like that. This is clear case of infringement. Adila and Paras, both of you can file a case against me and take compensation. Of course, you would want to have an injunction order as well that I should not be doing this in future. And give the possession of all the photocopied books to Adila or Paras. Okay, this is one thing. So ये तो एक clear case of infringement हो गया where things are done without consent. Other set of disputes arise in such situation. ये agreement हो गए, license हो गए. So when you do not have a clear contract, like Paras said कि अगर contract में लिखा होगा कि किस तरीके से हम चीजें करेंगे, किस तरीके से publish करेंगे, then it will become easy because you have a written contract. You can interpret it and reach to a conclusion. But the problem arises when things are not clear in your contract, or when you have to interpret it to that extent that you have to reach to a conclusion. So then you look at law. That what does the law say? Right? Is there any provision that says that if there is a publication agreement between Adila and Paras, then all the rights, including right to translation, is also transferred to Paras? It is actually a translated version, right? दूसरे language में आपने change किया है. So when Adila and Paras entered into a contract, whether it was implied that right to translation is also transferred. That is the question that has to be addressed primarily, right? So now the question arises, how do you look for these questions? Where do you look for the answers? ये सिर्फ एक example है. आप you can think on your own.
Ma'am, you are on mute.
You're on mute. Yeah. Okay. So you can think on your own कि किस तरीके के license agreements हो सकते हैं, क्या-क्या issues arise हो सकते हैं. So this is where the role of a lawyer comes into picture. And this is a very big industry, right? Not just publication house, you look at any industry जहाँ पे IP involved है. Google, Apple, Microsoft, ये सब भी अपने technology को लेके every other day they enter into contracts, they license them, right? Entertainment industry, Netflix, music companies, Sony Entertainment, and so on. They also enter into a lot of contracts. This is where the role of lawyer comes into picture. First, drafting of agreements. Thinking about from IP perspective, कि IP के क्या-क्या clauses होने चाहिए. It's not that कि ये सिर्फ IP का contract होगा. It will have a lot of other things as well. But a lot of chunk of the contract will also have clauses related to IP. कि rights क्या है, royalty कैसे share करेंगे, contract terminate कब हो सकता है, infringement कब होगा, and so on. Okay, so you have to think from both the parties. अब फॉर एग्जाम्पल आदिला एंड पारस का जो कॉन्ट्रैक्ट होगा, पारस सोचेंगे एज अ पब्लिकेशन कंपनी कि मेरे पास जितने ज्यादा राइट्स आ जाए उतना अच्छा है, कि मुझे राइट टू ट्रांसलेशन भी चाहिए, मुझे ये राइट भी चाहिए, मुझे वो राइट भी चाहिए. सो ही वुड वांट कि मुझे आदिला को कम से कम पैसे देने पड़े, एंड आई हैव ऑल द राइट्स, बिकॉज इट्स योर बिजनेस. ऑफ कोर्स यू वुड थिंक लाइक दैट. Adila, on the other hand, will think कि नहीं, I should give only limited rights so that I can exploit it otherwise as well. If Paras is not offering a good deal, अगर पारस अच्छे पैसे नहीं दे रहे हैं तो आदिला सोचेंगी कि नहीं, I would not want to transfer my right to translation and other rights. I would want to venture out with other publication companies as well. Okay, so those kind of negotiation, ये फिर negotiation होगा जब आप contract करेंगे. तो usually ये market ड्रिवन होता है कि मार्केट में क्या प्रैक्टिस चल रही है. यूजुअली पब्लिकेशन जब कॉन्ट्रैक्ट्स होते हैं, क्या रॉयल्टी शेयरिंग है. आदिला का रेपुटेशन विल आल्सो मैटर एज एन ऑथर, right? Because every contract is all about you have studied contract. It's a negotiation between two parties. So whichever has a better existence or better reputation will perhaps have a better say in a contract. So it will depend upon your reputation as well when you enter into such contracts. Okay. Now, Paras, in this case, Paras can file a suit against Pratap and Adila as well, right? Pratap will have his own line of argument saying that my contract was based on Adila's contract, and Adila made it clear that she has actually not transferred right to translation to Paras and so on. So a lot of it would depend upon how was the contract between Adila and Paras. उसी के बेसिस पे डिसाइड होगा कि प्रताप का आदिला के साथ कॉन्ट्रैक्ट वैलिड है या नहीं है, या इसको इन्फोर्स कर सकते हैं या नहीं कर सकते. ओके, ऑलराइट. Okay, so I can see two new faces. Debayan, I've spoken to Debayan. Hi, Victoria. Am I audible to you?
Yes, ma'am.
Okay.
Hello, ma'am.
All right. Do you want to give your introduction, because I'm meeting you for the first time? I think we did not meet yesterday, right?
Yes, ma'am.
Yeah.
Okay, I'm Victoria Shogade, a AF4 law student from the University of Lagos, Nigeria.
Okay. And so have you studied intellectual property rights and so on?
Yes, ma'am.
Okay, great, great. Okay, so what we were talking about is the basics of IP or fundamentals of IP, and then so that it helps you to write blogs and solve practical problems. Okay, so in case you have any doubt, please feel free to ask. Right, so, okay, so you understood, right? The kind of disputes, or as a lawyer, how do you have to think when you draft your contract? So Adila will have her own lawyers and Paras will have his own lawyers to negotiate and put it in contracts. Okay. Now the next question was, okay, which is the law? Where do you look for the law? How do you find answers? That is the question. So when you're going to interpret the contract, of course, you will have to look at some legislation also. Whether you find the answer in the legislation or do you find the answers in the case laws? Yes, Debayan.
I think it's both.
It's both. Sources of law. I'm sure you all have studied sources of law. So you look at legislation, you look at case laws, you can look at commentaries as well. Right? Good commentaries जहाँ पे law को interpret किया. Okay. So now comes to legislation that at the international level, do you have any law which internationally governs intellectual property?
Ma'am, we have the Berne Convention on Copyright.
Conventions. So let's now talk about conventions. Okay. So what are conventions, international treaties, agreements? Are they enforceable in individual states or individual member countries?
I think it's dependent on whether they're a signatory or not of the convention.
Okay, right. So there are a couple of legendary IP conventions. Okay, and Bern Convention is of course one of them. You have Paris Convention. These are two legendary conventions. Paris Convention deals with patents, or let's say industrial property. I'll come to what industrial property is. Bern Convention deals with copyright. Okay. Now, why do you need conventions? Why do you need international agreements? So the idea was to have certain minimum standards in place so that every signatory country adheres to that. So let's say Adila's book is published in India. All right. And Indian legislation says that copyright over books will be for a period of, let's say, 70 years. Life of author plus 70 years. Okay. Now Adila wants to sell her books in US as well. Okay. Now she wants to know, or she wants to ensure that her rights are protected in US as well. And let's say US says that if you are from India, I'll give you protection only for 30 years. Okay. So to avoid these kind of situation, to ensure that every citizen of these different member states get similar kind of treatment across globe, you have international conventions in place. Okay. So that there are minimum standards which every nation, every country adheres to. And there's no differential treatment also. So it should not be like that US gives more duration to a citizen of Germany and gives less protection to a citizen of India. So to avoid those kind of situation, differential treatment to ensure that everyone is treated equally and there is a minimum standard that is followed across globe, you have international conventions in place. So it is a kind of agreement that countries or member states have agreed to. And accordingly, they have drafted their own national legislation. Okay, right? And these international agreements are actually monitored or regulated by WIPO. WIPO is the international agency that governs international agreements as far as IP is concerned. ठीक है, a website देख लेना WIPO की, World Intellectual Property Organization. All right. So there are a lot of international agreements, and Paris and Bern being two of them. Okay, so a lot of conventions, treaties keep coming. So you check WIPO website, you'll find a list of those agreements. Now the next question is, now let's come to national legislation. Okay, so for trademark, you have Trademarks Act of 1999. For copyright, you have Copyright Act of 1957. For patent, you have Patent Act of 1970. For designs, you have Designs Act of 2000. For geographical indication, you have Geographical Indications Act of 1999. Okay, so for every category of IP, you have a specific legislation. But there are few so-called IP that we claim that they should come under IP, but you don't have legislation for that. Okay, for example, traditional knowledge is one of them. So a lot of debate is going on that how do you protect traditional knowledge? So a lot of countries who have a lot of traditional knowledge contend that it should also be protected under intellectual property rights, but you do not have a legislation for that. Okay, I'll come to what traditional knowledge is. So far, just keep this thing in mind that for most of the IPs, you have legislation in place. But there are few IP which are claimed to be IP, there's no legislation. Okay, right. Now there's one thing that you will come across when you read articles or when you read books. It says IP is territorial in nature. Okay, or IP laws are territorial in nature, or IP rights are territorial in nature. What does that mean? Anyone, any idea? What could this possibly mean when someone says IP rights are territorial in nature?
Basically,
Or
it means
let me put the question in a different manner. So the question is, let's say I as a business owner, I say that my trademark has an international registration. Okay, so let's say XYZ, there's a logo, let's say IP Press. Okay, so I say IP Press logo or brand, we have an international registration. Is it a correct statement to make? No. Okay, Debayan, would you like to elaborate? Yeah.
As we said that it's we need to get registration in different countries because they have different laws, and under those we need to get registration. Like if we get registration in India, so we also have to get the registration process done in USA as well. So that's why we can say without this we will not get protection in different countries. So that's why we say that it's in territorial in nature.
Partially correct, not entirely, but thank you. Okay, so what he said is right partially, that there's nothing like international registration, be it any kind of IP, trademark, copyright, patent, design. So if I make a statement that IP Press has an international registration, it is a wrong statement. Okay? Because laws are territorial in nature, in the sense that Trademark Act of 1999 can only be enforced in India, right? So if the law says, if the Trademark Act of 1999 says that you should get your mark registered in India, it means you can enforce your rights only in India because you have only complied with Indian Trademark Act of 1999. You have not complied with US law or UK law. So if you wish to protect your mark in US or UK, XYZ country, you have to look at their legislation. Right? So there's nothing like international registration as far as IP is concerned. So IP laws can only be enforced in your country. Okay? This is what Debayan said, and correct to this extent. Now there's a second part to it, which is registration mandatory under every legislation? Is there any law which says even if you have not registered, even if you have not complied with the legal requirements, then also your rights will be protected? The answer will be yes.
Copyrighted.
Even trademark, even trade. Okay. So now, again, as a lawyer or as a IP, let's say trademark agent or patent agent, etc., you need to know कि registration जरूरी है या registration जरूरी नहीं है. Or even if your IP is not registered, will you be able to seek some remedy from the court of law? Answer will be most probably yes in few cases, no in few cases. Okay, so let's talk about trademark. Again, under Trademark Act, it is not mandatory to register your mark. ठीक है, so it is not necessary कि आपने application file किया, form भरा आपने, and then there is a procedure, and then you have a certificate. But yes, it is advisable because it becomes easy for you to contend in the court of law that you are the owner of this brand. It has an evidentiary value, right? But the law does not mandate registration. Okay, so even if you're using, by usage also you can develop your rights. Right? So it can be, you can acquire rights by filing or by registration. You can acquire rights by usage also. Okay? तो इसमें दो concept होते हैं, first to file, first to use. Now again it depends कि countries क्या follow करती हैं. So there might be a situation that there is an XYZ country that says that it is mandatory to register your trademark, only then we will protect your rights. ये possible है. But as far as Indian law is concerned, we do not mandate registration. Okay, but most of the big companies, if you have if your mark has a good reputation in the market, if you want to protect your rights, then it is advisable that you file an application, get a registration, because then it becomes easy to prove ownership. Otherwise, फिर आपको prove करना पड़ेगा first to use. Right? First to file is, or you have a registration, or first to use. So you will have to prove with documents कि हाँ हमने 1967 में business शुरू किया था, and that's how we started. Or you started your business in 2000, हमने पहले use किया, पारस ने बाद में use किया logo if there is a dispute and so on. Okay, so that could be. So every country can have their different understanding or different requirement of protection. Now coming to copyright, copyright में भी same चीज है. Registration is not mandatory. The moment you publish it, it is considered as yours. But then again, the point arises, how do you prove that you published it first? Right? So to avoid those kind of situation, it's better that you register it and then you have ownership. You have an evidence. How about patents? How about patents? Any idea? Any idea about patent law? Think from ऐसे सोचो थोड़े lawyer के perspective से, थोड़ा business के perspective से, and then give me an answer. Yes. Do you think patent में, अच्छा, what do you think? Patent में registration mandatory होना चाहिए या नहीं होना चाहिए? Anything?
होना चाहिए मैम.
होना चाहिए? Okay. Okay, so yeah, so as far as Patent Act of 1970 is concerned, it says before you launch your innovation or technology or machinery in the market, it is mandatory that you get it registered. Okay, and if you don't get it registered, the consequence will be that you will not be able to protect your rights. So let's say मैंने कुछ light बनाई है, okay, XYZ machine बनाया, technology बनाया, मैंने application file नहीं किया, registration नहीं किया, and then I started selling it in the market. Later on, what Chirag did, Chirag copied my technology. He also started manufacturing. He also started selling it in the market. Now I filed a suit against Chirag saying this is infringement. Okay. Now the question is that the law requires that I should have got a registration done of my innovation, which I did not. So I may not be able to enforce my rights against Chirag. Chirag can very well manufacture the same thing and then can sell it. I won't be able to enforce my rights. Okay, so you have to look at the intricacies of each and every legislation. That which registration requires registration, and under which legislation, even if you have not registered, it's fine. You will be able to enforce your rights. The trademark and copyright are those two. But as far as patent is concerned, you may not be able to protect your rights if you have not registered. Okay, I'm talking about India, but more or less सब जगह same ही चीजें हैं. Then comes Design Act of 2000. Design also requires that you register your design before launching it in the market. Okay, so take any example, take shoes, take bags. Gucci का बैग है या Nike के shoes हैं या किसी कार का डिजाइन है ऑटोमोबाइल इंडस्ट्री में या ऋतु कुमार ने कोई लहंगा डिजाइन किया है या तनिष्क ने कोई ज्वेलरी बनाई है जिसमें कोई डिजाइन है. So if you wish to protect those kind of artistic work, then you need to register it before marketing it or before selling it in the market. Okay. Any questions so far? Okay. These things will help you when you do your research. That's the reason I'm telling you all these things. Now, quickly, can anyone tell me कि trademark में किस तरीके की चीजें आएंगी, copyright में कैसी चीजें आएंगी, patent में कैसी चीजें आएंगी, designs में कैसी चीजें आएंगी? Anyone?
मैम ट्रेडमार्क पे तो वी जनरली रजिस्टर लोगोज और डिजिटल मतलब मार्क्स जो होता है ना, जैसे कि लोगो हो गया, ये सब रजिस्टर होता है. कॉपीराइट वे it talks about idea.
अच्छा, trademark, tell me, look around you, everyone, tell me, do you see any trademark around you?
Yes, ma'am.
What trademark can you see they buy in your room?
The phone I'm using, it has an Apple logo, so
Apple logo.
which I can, it is on.
Okay, and?
Ma'am,
the
the Sprite.
Brand.
The what?
The tagline or the slogan any brand uses.
Yes, yes, correct. Can you give me any example of any tagline?
In terms of tagline, there's Nike's "Just Do It." The tagline. Yeah.
Yes, ma'am.
Correct. Any other trademark that you see around yourself? Just देखो तो आसपास. Look at the walls. Look at fan fixtures. Anything that you see? Apart from your phone, of course. Phone में तो सारे IP है.
Yes, ma'am.
Clothes that you're
I
wearing.
can see Adidas.
What do you
Yes,
see?
Adidas.
Adidas. Yeah. Adidas ki what all trademark Adidas has?
Adidas is a
Kind of
shoes
a wing,
design.
Yes, Victoria, please.
a kind of a wing shape with lines,
Yeah. True.
and
Correct.
it's black in color.
So Adidas has a logo that you have seen. Three stripes is also
Yeah.
a logo for them. True. Color combination as well. Okay.
Yes.
Okay. Correct. What about color? What about color? Can color be a logo? Logo to sabko pata hai, right? That was the basic, that was the most common example of a trademark. Logo. Everyone knows. Apart from logo, what do you see as trademark? And what is the function? Let's put it differently. What is the function of a trademark?
It's
What
an
is the function?
identifiable mark, like a distinguishable form of association. It's to know that it represents this company or this organization.
Right. It's an identification mark for a company. So basically, it tries to help you to identify the source of a particular product or a service. Not just a product, but a service as well. Okay. Which means anything can be a trademark. Why just logo? Right? The Act does not specifically mention that it is only a logo that can be a trademark. The definition is quite inclusive in nature. It says number, numeral, name, color, combination, pattern, design, shape. Anything can be a logo. Anything and everything under the sun which identifies a source can be a logo. So it keeps on evolving as well, right? So if you look at the marketing strategy 10 years back or 20 years back, logo is the classic example, and that's what we believe. And that's what comes to our mind first when we say what is a brand or a trademark. But if you look at the marketing strategy now, it has gone beyond logos. It can be sound, it can be a single color, it can be touch, it can be smell, it can be jingles, sound, and whatnot. And it will keep on evolving as well. Right? So any innovative way of using something, making a design, anything that identifies a source can be a logo. Okay. So there is an example. So again, if you Google unconventional form of trademarks, it will give you a list of example, and then you will be fascinated to know that even these can be trademarks. Okay. So one of the example that I wish to quote here is because here is that in EU, there is a particular brand. So they have stores, right? जैसे आप किसी store में जाते हो shopping करने, the moment you enter the store, you smell something, right? So there is a brand, and they have different stores in different cities in EU, and they have trademarked that smell, that experience. So when you enter that store, even if you close your eyes, you will be able to identify that you are standing in this brand. Okay, so some organizations or business have gone to that extent and protected their rights. Okay, now you may question that what is the commercial value of protecting these kind of things, right? So let's say Pratap wants to come up with a similar sense of trademark. He wants to trademark a different smell which is similar to their smell. Can he trademark that smell? Answer may be yes or no. Again, it will depend whether he's filing the application in EU or is he filing the application in India. Whether in India, our understanding has evolved to that extent that we are accepting such kind of trademarks. Or should he only be getting trademark in EU? Okay, so it will depend upon jurisdiction to jurisdiction as well. The problem with such kind of trademarks is that it is confusing. And it may not have that kind of commercial value as well. It may have, it may not have. So if Adila visits Chirag's store, and Chirag is also registered that smell, XYZ smell. Let's say rose smell or lavender smell or XYZ. It should not be common, of course. It has to be a mix of so many things that only it will be distinguished, right? Otherwise, as a consumer, I will not be able to identify Chirag's brand with that smell. It has to be different, right? अगर ऐसा कोई smell है जो मैंने बहुत बारी I have experienced it, it means it is not different. I won't be able to associate it with Chirag's brand. So it has to be different smell, only then it can be trademarked. But if Pratap also comes up with a brand and he wants to register slightly similar smell, as a consumer, I will be confused. So registrar might not grant registration to that particular smell. Okay? So these are those gray areas कि you will not be sure कि आपको registration मिलेगा या नहीं मिलेगा. But these are definitely very good marketing strategies. Okay? So trademark is not just to identify a source. You can use different sort of strategies that can give you some exposure or network, or it helps you to reach out to your customers, especially if your strategy is very new or novel or unique in the market, right? Okay, so there are a lot of so trademark can be divided into conventional form of trademarks and unconventional. तो ये अनकन्वेंशनल में सारी जितनी भी अतरंगी तरीके की चीजें आती हैं, स्मेल, टच. So you touch the fabric, you touch the paint or the wall, and if you are able to identify, okay, Asian paints there, maybe, why not, right? So all those kind of unconventional trademarks are being used by companies because these are new. It helps you to build a reputation in the market. Logo तो बहुत पुराना तरीका है that okay, I have a logo and this is my trademark. So apart from logo, companies have sound mark as well. Color भी use कर सकते हैं, smell भी use कर सकते हैं, and so on. So it is not that for single product you will have only one mark. You can have multiple marks. Okay. Any question in trademark? Of course, there are a lot of things to study, but again, I'm not going to teach you IP. I'm just helping you to write blogs. Bas. And do your research as far as solving problems is concerned. Any question related to trademark? No? Okay. Let's take 5 minutes break and then we resume, and then I'll tell you copyright, patent and design, and then we'll quickly finish. 5 minutes break. Okay, so it is 11. We meet at 11:05. Okay. All right.